Fuller versus First Financial Insurance Company.
Mr. Itzkovitz?
Good morning, Your Honors. May it please the Court. My name is Mark Itzkowitz, and I represent the plaintiff, Jane Doe, individually an assignee of the rights of Robert Fuller. Your Honors, this case returns to the Court the issue that had been raised and argued in the Bagley versus Monticello case a number of years ago, but not decided in that case. And that question is whether or not an assault and battery exclusion in a liability insurance policy bars recovery of damages which the underlying judgment has explicitly found to have arisen from rape, or in this case rape and kidnapping, as distinct from arising from assault and battery. And what we're asking in this case, Your Honor, is that Your Honors reverse the decision of Justice Muse that the exclusion bars those damages. His decision, of course, being the opposite of that had been reached by Justice Welch when the same issue came before the Superior Court in Bagley. As in Bagley, Your Honor, in this case, the underlying court reached a judgment which made explicit findings of fact based upon submissions of evidence before it, and assigned damages, in this case in the amount of $2 million, assigned half of those damages to those damages that arose from the assault and battery, and the other half to those damages that arose from rape and kidnapping as distinct damages. Unlike in Bagley, Your Honor, there is no other exclusion at issue in this case, and so this case squarely brings this issue back to the Court. And in essence boils down to the question, then, Your Honor, whether for purposes of the exclusion, rape and kidnapping are synonymous with assault and battery.
Mr. Itzkovitz, just a minute. I take it that the insurer has not contested that the sexual assault exclusion is not at issue, correct?
That's correct, Your Honor.
That's out. So we only – okay.
That is out. So we're left just with the assault and battery exclusion.
Okay.
Your Honor, I suggest that as a matter of fact, there is no question that rape is not synonymous with assault and battery, and I suggest
but that's not the point, really. Of course, it's not synonymous. I guess murder is not synonymous with assault and battery either, but death can arise out of an assault.
Indeed.
And so it's not a question, is it synonymous? Did the damages here arise out of an assault? And what's the difference between a sexual assault and some other kind of assault? Assault with a weapon, assault without a weapon? I mean, they're all assaults, aren't they?
Well, the differences are manifold, Your Honor, and the elements, to be sure, overlap. But the fact that they overlap is not the end of the analysis, as it was in Justice Muse's situation. The fact that they overlap, I suggest, is the beginning of the analysis. The distinctions between rape on the one hand and assault and battery
assault or battery, arising out of assault or battery.
Or battery, as in this case, Your Honor, yes, are many, and indeed, Your Honor, the
let me ask you a question, though. Even if you prove that assault and battery doesn't apply to rape, don't you also have to prove it doesn't apply to kidnapping?
Yes, Your Honor.
Don't you have a harder time there?
I don't think that we do, Your Honor, because, again, that decision, and I refer, Your Honor, to the Ledbetter case. The elements in Louisiana where the Ledbetter case was decided are essentially the same as they are in Massachusetts, Your Honor. Kidnapping, to be sure, can arise from the use of force, but it need not. The law of the Commonwealth for over 100 years has been that any restraint of a person's liberty constitutes kidnapping, and there are a number of decisions, Your Honor, holding that the confinement or the aspiratation that is used in rape is not the same as that occurs in kidnapping. There's been a recent decision by the appeals court to the same effect following along this Court's decision in Commonwealth v. Rivera and Commonwealth v. Perry.
So the kidnapping here clearly is a result of an assault. Right?
I'm sorry, Your Honor?
The kidnapping here is clearly the result of an assault. Knife to neck or whatever it was. I mean,
Yes, it did happen that way, Your Honor. But again, Your Honor, that issue was presented to the Superior Court on the question of the damages, and there has in fact been an award recognizing that there were damages from the kidnapping, that there has in fact been a recognition that there were damages from the assault or battery.
Well, I'm sure.
And
sure
we're not
there were.
seeking that.
But it seems to me, we don't, seems to me, to look at this in the abstract. Can we conjure a kidnapping or a rape that somehow doesn't involve or even arise out of an assault or battery? It isn't a question whether we could hypothetically conjure such a thing. It's a question of what happened here. And it seems that here there was an assault and a battery that occurred while she was on Fuller's premises, and that was how she was kidnapped. She was raped elsewhere, not on his premises. The whole theory of liability is that the ultimate rape arose out of the assault and battery that took place on the premises. Otherwise, you couldn't even get damages for the rape. We look at it seems to be a broad view of arising out of and apply it to the specific facts of the case, not the hypothetical of could somebody perpetrate a kidnapping without an assault or a battery.
Well, I think we come back to that, Your Honor, here. And again, of course, we're dealing with this in the context of the interpretation of the language of the exclusion. And what I think the Court is suggesting is that the assault or battery exclusion is in fact a broader exclusion than what it is. And I think that we have to come back to certain basic elements of construction on this one. What Your Honor is suggesting, and the reason why I say that the overlap of the elements is the starting point of the analysis rather than the conclusion of the analysis, is this. The policy, of course, is interpreted from the standpoint of a reasonable insured. And the question becomes, and there are now a number of cases around the country, to the effect that in the popular understanding, rape and assault and battery are not the same thing. And the insurance companies, we have to recognize, Your Honor, are attempting to deal with that as well. There was in the Superior Court, not in this Court, Your Honor, the question of whether the sexual assault exclusion applied. There have been a number of sexual assault exclusions that have been in use since the late 80s, certainly in the 90s and to the present time. There are criminal acts exclusions that have been added to insurance policies to deal with the various types of crime and to deal with them on a broad scale. But what we have here, Your Honor, is a situation where the insurer is trying to use language which is archaic and which is based on an understanding of legal elements of four distinct crimes, as we're dealing with in this case: assault, battery, rape, kidnapping. And an assumption that in the popular understanding, in the understanding of a reasonable insured, that they will understand that the elements of these four distinct crimes overlap, and therefore the arising out of language is broad enough to cover that. I suggest, Your Honor, that in truth that's not the situation. If we were to go into any auditorium, for example, and ask the people there who has been assaulted among the crowd, we would get a certain number of hands that may very well answer that question. If we were to ask the question, who has been raped, and if we would ask them in the reverse order, I suggest that the answers would not necessarily reveal the same people, because in the popular understanding, they are not the same thing. And indeed, Your Honor, in a slightly different...
I don't know. We commonly use the term sexual assault to encompass both indecent assault and battery and rape.
We do it, Your Honor, and we do it, of course, in a historical context. And my suggestion, and I think no court is more aware of it than this Court is that that historical context is not necessarily factually accurate. That the social science research, which this Court has used for a very long time, and most recently in the Commonwealth versus King case, when it reanalyzed the question of rape in the context of the fresh complaint and now the first complaint rule, shows that the popular understanding, the historical understanding, is not necessarily an accurate one, and indeed is based upon a number of false assumptions. And it was in King again, Your Honor, that this Court said that, we're trying to deal with truth. We want the jury to make we want the jury to make decisions based on reality as it's understood from social science, from medical research, from what we now know to be true about rape, not from the false premises that we've inherited from common law.
Those are all about what victims of that particular crime tend to suffer.
I'm sorry, Your Honor?
It was the things you're pointing to that we cited in King and all of that research are about things that rape victims or sexual assault victims tend to suffer because of the nature, the particular nature of that kind of an assault. But it doesn't seem to me to change the fact that it is still conceptually an assault. In fact, it's a battery. It's just that the nature of the harmful, offensive, and unconsented to touching happens to be of a very specific kind, namely penetration. But it's still a battery.
It is a battery, Your Honor, but I think that the case law for the last 75 years, has stressed that it's not the battery. It's not the touching that gives rise to this crime. That's not the essence of the crime. In Goldenberg, this Court said that the essence of the crime essentially is the outrage, the injury and outrage to the feelings of the woman caused by the battery. The battery is incidental to the nature of the case. That's the language, in fact, that's picked up by the dissents in the Ledbetter case out of Louisiana. And, you know, on sort of the flip side of the analysis, Your Honor, there was a case recently out of Florida, the Mason case, where the question came up not in the exclusion context but in a coverage context. And the Court pointed out this exact distinction. And the language of the Mason case acknowledged what Your Honor is suggesting. Technically, sexual battery is a form of battery, but is sexual battery what is commonly meant by the term battery? Insurance contracts must be read in light of the skill and experience of ordinary people, our language of the reasonable insured, and must be given their everyday meaning as understood by the man on the street. Since the everyday meaning of battery does not mean rape, the policy should not be construed, in this case, to cover it, in our case, to exclude it.
Mr. Itzkowitz, may I ask you a question? By analogy, in the criminal law field, if a person is charged with rape, a judge will explain to the jury what the elements of the offense are. Wouldn't
Yes,
assault and battery be considered lesser included offenses?
They would be, Your Honor. And the jury...
Does that mean that you could define it by using assault and battery?
You could use it to define the starting point. And the distinction, Your Honor, I suggest is that in the context of a jury trial, the Court would define it for the benefit of the jury. The jury would have that understanding. But we're dealing with the world outside of the courtroom.
And to just expand on that a little bit, we have model instructions that are used all over the state, and they all use that language. And they don't say to the jurors, well, you can use your popular understanding. They explain these are the elements. Isn't that how it works?
That is how it works in the courtroom, Your Honor. But we're dealing with an insurance policy that's being dealt with by day-to-day people on the street without the benefit of that education, without the benefit of the court explaining what the legal analysis are. And what we're now doing is asking...
I guess what I'm saying is if we use that definition in the criminal law, shouldn't we use it in this arena as well?
No, we should not, Your Honor. Because in this arena, Your Honor, we're dealing outside the courtroom, outside the benefit of the kind of instruction that Your Honor is suggesting. And what we're doing by doing that, Your Honor, is we're doing exactly what the decision in Hazen said cannot be done. We are incorporating jurisprudence to narrow the scope of an exclusion. We are incorporating a legal understanding and putting that into the minds of the folks who deal with this on a day-to-day basis. They don't have that.
Mr. Itzkowitz, I mean, the difficulty here is I'm not sure if you asked a consumer who purchases a policy what the difference is between assault and battery, correct? I mean, you and I know it because we're lawyers, and somebody told us there's a difference between an assault and a battery. I tend to think that any consumer, though, would think of rape as a form of assault, even though technically it may be a battery.
Well, I think we're putting ideas into their head that aren't necessarily the case. And again, Your Honor, you know, it sort of comes back to the question, if you step back from it and say, well, look, what happens if, in fact, we hold them to the exact language, which is the language of a number of cases, that they have to apply the language that's used in the policy. If we hold them to the exact language of the policy, in the context of the assault and battery portion of this case, the clause clearly is not ambiguous. It is an assault and battery. We're not seeking recovery for that.
Well,
but
if we're holding you to an exact language, could you answer what was implied in Justice Sussman's description of where these events occurred, which is if the rape did not occur on the property, isn't it arising out of an assault and battery?
It is arising out of the aspiration that, it's arising out of the incident that occurred there, yes.
When she was assaulted, was she not, on the property?
Yes.
And arising out of that assault on the property, she was taken off the property where some other events occurred. Wouldn't that be a clear reading of the terms of the contract?
Well, it would, Your Honor, were it not for the fact that, again, in the underlying case, that issue was presented to the court, and the court was asked to parse out those damages. And the court parsed out the damages, and the parsing breaks down to the split that we have here, Your Honor. We're only looking for that portion of it that the underlying court specifically found to be attributable to the rape and kidnapping damages, rather than the assault and battery damages.
Are you telling me that the insurer, First Financial, has waived a claim that because the rape occurred off the property, it doesn't, the language of the arising out of the assault on the property is the bar to recovery here?
I'm not claiming that they've contested their right to contest the scope of coverage and and the meaning of the clause. They have that right. What I'm suggesting, though, is that they are bound by that underlying fact-finding in this particular case. And that's the fact-finding that this case, the context in which this case comes to us, Your Honor.
No, somebody may well recover damages because of something that occurred off the property. That fact is not disputed. I don't think the insurer has to dispute that fact. It's the coverage issue.
Mr. Ickowitz, is there evidence in the record as to the change in the common understanding of the term assault and battery with respect to rape?
I don't think that there's evidence in the record, but what we have submitted, Your Honor, as part of the record is we submitted a number of the studies that this Court referred to way back in the Fuller case and various other cases, just to make it more convenient to the Court.
But were they submitted in the trial court?
Yes.
Okay.
Yes. Yes, and they were cited in the briefs, and we submitted them as a matter of convenience. And Your Honor, I would suggest that in Commonwealth v. King last year, the Court cited a number of times Professor Eileen Seiden's report, and I suggest that there's some language in there that's particularly important here, and the language is to the effect that part of the reason why we haven't seen the changes that perhaps we had expected from the last 30 years of rape reform law is because there are certain elements in society that haven't been willing to catch up or haven't been able to catch up with these reforms. And I think that what we're looking at is the kind of archaic language that has not caught up with it, Your Honor. And this Court has not hesitated in other contexts to rely upon the modern findings and the modern behavioral science, notwithstanding the fact that we are in the forefront. Thank you, Your Honor.
Thank you, Mr. Itzquist. Mr. Berman?
Good morning, Madam Chief Justice and members of the Court. May it please the Court, my name is Joseph Berman, and I'm here today representing First Financial Insurance Company and requesting that this Court affirm the summary judgment entered by the Superior Court in favor of my client. The issue in this case is one of straightforward insurance policy interpretation that has already been decided conclusively by the courts, both in this Commonwealth and in states around the country. The plaintiff's argument would radically change the interpretation of the clause that we're here discussing today, the assault or battery exclusion. Contrary to my brother's argument, there is nothing ambiguous or archaic about the terms assault or battery, or put in combination together assault and battery, as I think the questions from this Court recognized earlier in response to my brother's argument. Those terms are commonly used in the criminal law and in the civil law throughout courts throughout the country. They unambiguously encompass the conduct complained of in this case, and based on that, the exclusion clearly applies.
You didn't, I think the Chief Justice may have asked the other lawyer this, but you didn't appeal the judge's ruling that the sexual action exclusion was designed only to exclude acts of workplace sexual harassment and sexual abuse.
That's correct. We are here defending the appeal only on the issue of the assault or battery exclusion.
To what extent, if there's an ambiguity in the contract, and one is looking at it from the point of view of the insured, to what extent does an insured look at those two provisions and understand that, notwithstanding the fact that the sexual assault I don't want to say technically, by the contract terms covers workplace behavior, that this was a policy that was certainly not excluding sexual assault in the workplace, but including sexual assault on the property. Are you with me?
I think so, Your Honor. And I think what one would have to do if you were an insured reading this policy is look at each exclusion. And the exclusion that is at issue in front of this court is the sole exclusion for assault or battery. There's nothing ambiguous about those terms. An assault, as this court has recognized, is defined in the criminal law both by statute and by case law. A battery is also defined by statute and by case law. The crime of assault and battery is defined in Chapter 265 as part of the criminal law and by case law. And as Justice Sussman recognized, we have several laws on the books criminalizing indecent assault and battery or indecent assault, both on someone over and under 14. All of those crimes define the incident, the act complained of, in terms of an assault or battery. This court has recognized in the Fels-Aker case that an assault and a battery is a lesser included offense of a rape, just as it is a lesser included offense of indecent assault and battery on someone over 14 or indecent assault and battery on someone under 14. All of those elements are subsumed within the definition of assault and battery.
But Mr. Berman, I take it that Mr. Iskowitz is saying that the common understanding of the word assault or battery, as it's used in the insurance policy, is no longer as you're describing it, but it means something, at least with respect to rape. It does not include rape. What do you say about that and all the studies that were introduced?
I guess I have two responses to that, Your Honor. First of all, there's nothing in the record that would support this argument about the common understanding, and Mr. Itzkowitz is hypothetical about putting everybody together in an auditorium and a hypothetical survey about what the response would be. But secondly, this Court, in both the criminal law, well, in three contexts, the criminal law context, the civil law context, and more specifically within the context of civil law and insurance law, has defined those terms for decades, if not for centuries. And there's nothing archaic about them. Whether the popular understanding, as Mr. Itzkowitz hypothesizes that it may be something different, and I would dispute him on that, but there's certainly no evidence in the record to support him, doesn't mean that the phrase is ambiguous. Remember that the critical question is there something ambiguous about the phrase? And that only gets him to the point where we would construe that language against the insurance company. But an ambiguity is not created simply because lawyers may disagree about what the phrase means. And it's not created simply because the phrase may be general. There must be a real ambiguity in the phrase, and I would urge Your Honors to look at the cases from around the country that have addressed this precise point and held that there's nothing ambiguous about it.
Mr. Berman, I understand that argument, but could you address my question, which is why do we even get to that when the rape and I'm just leaving kidnapping aside for the moment, but the rape occurred off the property. I mean, as I read your brief, and I'm sort of looking at page, 10, 11, 12, when you're arguing that, absent the underlying assault and battery, Doe would have suffered no personal injuries. It's clearly what happened on the property was an assault and battery.
Absolutely.
Because I take it's undisputed that this victim was not raped on the property. Is that correct?
That is undisputed.
And I'm looking at the language, and it says it excludes bodily injury. I'm perfectly happy to concede that rape is to recognize that rape is a bodily injury, but it is arising out of an assault and battery that occurred on the property, correct?
Correct.
So why isn't that the beginning and the end of it?
I would agree, Your Honor, that if...
So I don't even have to get to whether or not rape is an assault and or battery within the terms of the contract, do I?
Right. I don't think you'd have to do, Your Honor, and I think that to find some support for that approach, you would look at, the Parrish case, which is an appeals court case, and all those other cases.
But you don't stop me dead and say, don't even get to it. You just go breezing on.
Well, but the issue is this, Your Honor, that you look at the entire event. You don't parse it into distinct elements. But the entire event began with an assault and a battery on the insured premises. The entire event then proceeded from the insured premises, Mr. Fuller's apartment complex, to the underlying criminal defendant's apartment, where the rape occurred. It is undisputed that the rape, the sexual assault, however you defined it, occurred off the premises. So you are correct, Your Honor, that what happened on the premises, the bodily injury, to the extent that there was any bodily injury attributable solely to the assault or the battery that occurred there, would clearly be excluded under the plain language of the exclusion.
So I don't have to, now, help me with the kidnapping.
Kidnapping, Your Honor, is
Because I take it the kidnapping at least commenced on the property, correct?
Kidnapping commenced on the property.
So then I have to reach, the court has to reach the question as to whether kidnapping in the circumstances of this case or any time constitutes an assault and battery.
Well, let me address the second point first, Your Honor, if I may. The way that the settlement was reached below, and in our brief we argue about whether we're bound by that or not, attributed $1 million of the damages.
I don't mind about that.
Right. But what they said was $1 million attributable to the rape and kidnapping, combining those together. So,
but for purposes of the contract interpretation, it's irrelevant it's legally irrelevant how the parties in the underlying litigation agreed to divide up the damages if there's no coverage, correct?
Correct. That's correct.
But again, I go back to go to kidnapping. You have on the property an assault and battery, correct?
Correct.
For which, let's say they've allocated $1 million. So everybody understands there was an assault and battery.
Correct.
Correct. Everything else arose out of the underlying assault and battery. Rape,
Correct.
Kidnapping, maybe he would have stolen some money, maybe he would have knocked over some trees, I don't know. Everything else arose out of the underlying assault and battery. Isn't that all excluded under the language
Yes.
of the policy?
It is, Your Honor. But I thought Your Honor was asking me about whether kidnapping would fall within the definition of the exclusion.
Because I didn't know whether the kidnapping independently occurred on the property.
Well, the facts as stipulated and as established in the underlying case are that Mr. Furrow, the underlying defendant, put a knife to the back of the victim and forcibly removed her from the insured premises to down the street to his apartment. So the kidnapping clearly commenced on the premises, but it's clearly an assault and battery.
Did it arise out of the assault and battery?
Absolutely, Your Honor.
Okay.
Absolutely. And all one has to do is look at how Massachusetts defines the crime of kidnapping, which simply says that without lawful authority, the defendant forcibly or secretly confines or imprisons another against her will.
What was the other $1 million put towards? Was that the negligent security?
No, the $2 million judgment, $1 million was put towards the assault and battery, and $1 million put towards the rape and kidnapping.
Oh, I see. Okay.
And there's no claim here that the $1 million that was allocated to the assault and battery is covered by this insurance policy.
That's correct. As I understand
again, forgive me for pressing you, Mr. Berman, but you've just given me a definition of kidnapping, and my question to you is, surely I don't even have to concern myself with what the definition of kidnapping is, because whatever happened, it happened arising, what's the precise language, arising out of. Whatever happened, it arose out of the assault and battery on the property.
Absolutely, Your Honor. And again,
so stealing a car, whatever it was, it all arose out of that.
That's correct, Your Honor. And again, in the Parrish case, which is an appeals court case, but as well as the Monticello insurance case, which is a case from this court, the phrase arising out of is obviously interpreted broadly in the context of an exclusionary clause, and it encompasses the entire sequence or combination of events. One doesn't look at them in isolation.
Yeah, I'm having a little bit of difficulty with that, because when you say that it encompasses the incident as a whole, that wasn't exactly your word, but isn't that what Mr. Itzkowitz is saying? He's saying you have to look at this as a whole, in the assault and battery, the breaking into the apartment and the assault and battery was really part and parcel of the defendant's or of the perpetrator's attempt to overcome the will of the victim in this case. So isn't the assault and battery and the kidnapping, isn't it all really part and parcel of an element of the rape, which is to overcome the will of the victim?
Well, I guess I think that's his argument, but I think the proper way to look at it is just the inverse, which is Mr. Furrow's attempt to rape the victim was all part of an overall assault or a battery. It was all part of his scheme, his common scheme to assault this woman on the premises, remove her from there to his apartment, and then raper. So it's all part of an assault or battery as those terms are defined in the law.
But when you're using the rule of construction that says you have to look at the incident as a whole, he's trying to flip this over so that the assault and battery is actually part of the rape rather than the rape flowing out of a distinct assault and battery. I mean, he's using the same rule of construction you are.
Right. And I guess my response would be it doesn't really matter, because even if one were to look at it, look at the rape in an sort of isolated fashion, the law, both civilly and criminally, defines rape, including the elements of an assault and or a battery. So however you define it, you still keep coming back to it's an assault, and in this case it's both an assault and a battery. And as I think one of your honors asked in a question to Mr. Itzkowitz here, it doesn't matter hypothetically or theoretically whether you could have a rape or a kidnapping that doesn't involve the physical use of force. Here, indeed, the incident was violent. It was both an assault and a battery, and there's no question about that.
Mr. Berman, can I ask you, bear with me for a moment. Let's assume this negligence case had been brought based on breaking and entering, and the claim was that this was effectuated because security was not appropriate. I take it that would, that might be covered by the policy, wouldn't it?
It would not, Your Honor. And again, I come back to Parrish, where the appeals court and then Bagley versus Monticello also said this, and subsequent cases have said that even if, the court is not bound by how the plaintiff pleads her case, the draftsmanship by the lawyer in pleading it. And these cases often are pled as negligent security, often in the cases involving schools.
No, but bear with me. I think you're getting ahead of me. So a breaking and entering that resulted in the loss of property.
Right.
That's all. Would that be covered? I mean, if there were negligence in providing the appropriate security?
And it certainly wouldn't be an assault or battery.
Right. Okay. So it might be covered, right? It wouldn't be excluded based on these exclusions.
Wouldn't be excluded under the assault or battery.
Let's assume that the robber inside the apartment stumbles across someone and basically places them in fear with a weapon while stealing the stuff from the apartment. What would be covered? Nothing, because there was now someone that was assaulted in the course of this burglary?
I think that certainly to the extent that if the plaintiff were attempting to recover for personal injuries, for bodily injury, because of the battery that happened, yes, that would be excluded. If she were trying to get her stereo back, that might be a different case.
Right.
But if it's a bodily injury, it would be excluded.
Okay, thank you.
I guess in summing up, Your Honors, I think I believe it was Justice Cordy recognized that the terms don't have to be synonymous in order to be unambiguous. It's clear in the case law that the terms assault and or battery encompass what happened here in this very unfortunate evening, that there simply is no coverage, and it is excluded under the first financial policy.
Mr. Berman, one last question. Have the terms of this policy been approved by the Commission of Insurance?
Your Honor, I believe that this is an excess policy, so I don't think it's subject to regulation.
Okay. Thank you.